The next case to come before the court is Malcolm Jones et al. V. Edwin Soto et al. Is everybody here?
Yes, sir. Yes, sir.
Very well. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so I ask that you stay behind the podium, keep your voices up, please introduce yourselves. Please don't use the names of children or minors or victims should that be applicable in your argument. Only refer to those folks as by their initials or generic terms. The judges have read your briefs and we are ready to proceed when you are. And I would just ask the appellant, would you like to reserve time for rebuttal?
I'm going to do my best, if that's okay. Thank you. May it please the court, my name is Joe Levesque, and I'm an assistant law director and police legal advisor for the city of Lorain. I am here on behalf of Edwin Soto and Orlando Colon. They are the appellants in this matter. This is an interlocutory appeal from Lorain County Court of Common Pleas case 22CA011870. The standard of review for this honorable court is de novo. I wanted to start by providing some background information. The Lorain Police Department created the Community Impact Unit, which is a unit designed to target high crime areas and the most serious crime that's committed in the city of Lorain. We're talking gangs, drugs, moving women, kids, guns, really bad stuff. This unit partners with different federal agencies. At this time, they received a grant from the Department of Justice to target gangs and other violent crime. That's why Edwin Soto, who was a U.S. Marshal, was with Orlando Colon, who was the crime analyst for the City of Lorain Police Department. Mr. Davis, Javian Davis, was a known Southside gang member. He resided at a residence that we identified as a trap house, which is a place in which gangs conduct gang activity, like selling drugs. In the week leading up to the incident identified in the appellee's original complaint, that house was shot at 3 different times. There was at least a dozen shots fired between Southside gang members and Westside gang members leading up to April 13, 2019. Mr. Davis was suspected of being in at least 2 of those shootings and an additional shooting the morning of the incident that we're here to talk about today. On April 13, 2019, Edwin Soto and Orlando Colon were patrolling in the south side of Lorain. For those of you who aren't super familiar with Lorain, the south side of Lorain has a heavy Puerto Rican and Hispanic population. Both of these gentlemen are Hispanic and we're Puerto Rican. They're very familiar with that neighborhood. They patrolled in that neighborhood countless times. They identified Mr. Davis driving a vehicle. Mr. Colon knew that he didn't have a driver's license. He knew all of the information I just provided to you. And he knew that because as a crime analyst, he would actually read every single report that was generated. He would review all calls for service. He would map out shots fired throughout the city. And so this was an intelligence-driven law enforcement operation. This was not simply a cop sitting at a corner waiting for someone to drive by. Davis was identified. They knew that there was an active gang war going on. That leads officers to reasonably conclude that those folks who are members of those gangs are more likely to be armed than not. So they have some reasonable suspicion that he was involved in a shooting the morning of. They have reasonable suspicion, or I would say they knew for sure he didn't have a driver's license. When they made visual contact, Mr. Davis was driving erratically. So at this point, I would submit to the court they had reasonable suspicion that he was OVI. Now, the officers attempt to initiate a traffic stop. They utilized their lights and sirens as they approached West 31st Street and Fulton. Now, Davis then turned onto Fulton. He continued to drive erratically, and he started pulling towards the curb as if he was going to stop. Now, at this time, he has his left hand like this up on the steering wheel. He's exhibiting furtive movements, which law enforcement, of course, associates with someone concealing drugs or guns. And as he's doing so, by reaching down underneath his seat, the wheel is being pulled to the right. So as he's doing this, he's continuously bumping into the curb to the right of the lane of traffic in which he was traveling. Now, instead of stopping, Mr. Davis then takes a right-hand turn, and he guns it down East 29th Street. East 29th Street is a dead end. At the end of that street, there's a fellow that was living there by the name of Ali Jihad Campbell. He's also a Southside gang member, and that was a Southside gang stronghold. The officers believed that Davis was going to exit the vehicle and hide out at Mr. Campbell's residence. He, of course, didn't do that. Now, I should note that by the time Davis guns it down 29th Street, 16 seconds have lapsed. When I first started this narrative, from the beginning, when they first made contact and try to initiate a traffic stop, until the time that Davis crashes into Appley's vehicle, there's a total of 31 seconds from beginning to end. So over 50% of the entire incident that we're talking about here today involved the officers simply trying to initiate a traffic stop in the manner that I just described. The only time period in which there was active flight by Davis was from that 16-point second on as he was fleeing down East 29th Street.
And is it factual that the officers drove through something that wasn't the road?
That's correct.
And also that pedestrians may utilize that field to cross, to go to a grocery store or to other places?
So the field in question is behind a Walgreens. So it's essentially a commercial lot that some people will transverse. And I know Applebee's made much to do, if you will, about that grassy field. The fact of the matter is, though, there is not one iota of evidence in the record that there was a single soul on East 29th Street. There's no evidence in the record there was any traffic on East 29th Street. There's no evidence that there was a pedestrian on East 29th Street. There's no evidence that there was anyone in the field as this incident was occurring. And so what I would submit to the court is that, the Supreme Court's been really clear about not creating perverse incentives for fleeing suspects. And I think that the way that the Supreme Court articulated, Your Honor, is if someone is fleeing and they were to drive in excess of the speed limit, they were to cross some double yellow lines, they would otherwise drive in a way that presumably is making it less safe for the motoring public. That in and of itself cannot be a sufficient condition for termination of a dangerous person, for a pursuit in general. And certainly I think it would be, I would humbly submit to you, it would be inappropriate, in my opinion, to issue a ruling that essentially, as long as someone is going off a paved roadway, regardless if anyone is there, that would necessitate a termination of a pursuit of a dangerous
Is it
person.
against Lorain Police Department policy to go off the roadway in a pursuit?
No, Your Honor, and I'm glad you asked that question. Applebee's suggest and assert in their brief that LPD policy was violated by way of going into the grassy field, and they argue because someone could theoretically be there. But if you look at the LPD policy carefully, what it says is where people are. Where people are. I am here right now. It's not a theoretical question about where someone could be. If that's the case, I would submit to the court that you could never really engage in a pursuit. There's people could theoretically be anywhere, right? But in this particular instance, there were no people in the field. So what the policy said.
If there was a violation of departmental policy, would that undermine immunity?
I would submit to the court, no, Your Honor, because I believe that the mandatory authority in this court is that a violation of departmental policy is only one of the 14 factors analyzed under Hoffman, but in and of itself, as a singular factor, a violation would only amount to negligence and not recklessness, which is being alleged here today. Of course,
In recklessness, you're supposed to be considering factors, like
yes.
if the officers were driving on the road or if they were in the right lane.
One of the
and
factors.
whether there's disputed material facts here on that issue.
I don't believe that there is, Your Honor. I
And
think.
so it's not disputed that you were that the officers were in a grassy field that sometimes pedestrians walk in, but the allegation is it's disputed in the affidavit about speed and if there was a hot pursuit and those types of things, right?
So I think the case law is really clear with respect to what's stated in the affidavit. A bald, self-serving, conclusory affidavit is not sufficient to meet the reciprocal burden that a non-moving party has to survive an otherwise properly pled motion for summary judgment. There is nothing in that affidavit that refutes or rebuts the deposition testimony of the officers.
There's multiple affidavits though attached to their motion.
Yes, but they
eyewitness
say the same
testimony.
thing.
And expert, an expert as well.
There is.
Does the expert compete with, are the experts competing within the affidavits, their testimony?
We only have expert reports, Your Honor.
Exactly, so are those competing reports?
The expert that the officers hired is a reconstructionist.
Okay,
So we can tell you, we analyze the airbag module data, we can tell you how fast these cars were moving, I can tell you how fast Mr. Davis's car was moving, 5 seconds prior to impact, how fast he was moving at impact. Dr. Lyford is a liability expert. He's a gentleman who provides the cops are liable because of X. But also, the case law in this jurisdiction is very clear that just in fact, this court in the Anderson v. Westlake case just ruled on this very issue back in 2020, which is to say, just because an expert says that person A was acting recklessly, that again is insufficient for the purpose of denying a properly pled motion for summary judgment. So, for example, based upon our expert's report and analysis, Mr. Davis had a curved trajectory in order to avoid some of the natural barriers in the grass, was in the grassy field for approximately 7 seconds. 7 seconds. The 5 seconds prior to impact, he was traveling somewhere between 57 miles per hour and 69 miles per hour. At the point of impact, Your Honor, he was traveling 64 miles per hour.
And we know this because,
The airbag module data was analyzed by our expert, Mr. Hankey.
and is there dash cam video?
There is not, Your Honor, unfortunately. I really wish there was.
The trial court seemed to found there was a question of fact as to whether your officers are going 30 or 35 or traveling at a high rate of speed.
Yes, Your Honor.
Do you agree there's a question of fact about that from the test of the affidavit and expert reports?
I do not, Your Honor, and the reason I don't is because the affidavit that I've already described as being bold, soul-serving, conclusory in nature, doesn't qualify in any way what the officer's speed was. It's an opinion about their speed. If I was driving on my front lawn, and I live in a residential neighborhood in Avon, if I saw a car go by at 35 miles per hour, I might say that they're going at an unsafe and fast speed. But that doesn't mean that they weren't going 35 miles per hour. The affidavit provided by the appellees are conclusory, and in my humble opinion, they are opinions about facts. But I would go a step further, Your Honor, even if the officers were going faster than 35 miles per hour. And let's say that they were driving closely. I don't know what that means, by the way. It's this amorphous term that, in my view, is only there to raise some question of fact. I don't believe it's genuine. But imagine you were playing a game of tag, and the person that was it had to jog, and the people who were trying to get tagged could sprint. I don't know that we can exist in a space in which law enforcement officers are not allowed to at least drive as fast as the people that they're trying to apprehend, which they have a statutory obligation and duty under the law to do. We're also talking about a 15-second incident from beginning to end. I would also add that even if Mr. Davis was driving 57 miles per hour, we know he was driving faster because he crashed at 64 and he got up to 69. He was using 100% accelerant when he got off the paved roadway, intermittently applying his brakes. If you're traveling 57 miles per hour, you're traveling 83.6 feet per second. That means at the very minimum, he was 336 feet away from the grassy field. That is an entire football field. Now, if he was driving 64 to 69 at points in time, which we know he was likely a football field in a third away from the grassy field. So I think I would humbly submit to the court that the grassy field is like smoke and mirrors. The appellees want the court to believe that the grassy field was the cause of the accident, but there's no expert testimony to that effect. There's no lay witness testimony to that effect. There is literally nothing in the record that suggests that. I would also add, with respect to the officer's testimony about where they were when the accident took place, the officers testified that they were in the grassy field when the accident took place. The only evidence in the record about where the officers were is saying that they were closely behind and they were traveling at unsafe speed. Again, this is some amorphous description that, in my opinion, cannot possibly be raised to a genuine issue of material fact. If that is all is required during a pursuit in which a third party is injured, you're going to see a lot of bold, self-serving, conclusory affidavits saying that the law enforcement were driving in an unsafe manner. I would submit to the court that there is no way in which you can engage in a pursuit that is 100% safe. And one of the Hoffman factors is, did the officers engage in this, was there a less dangerous means or something to that effect? I have some issue with that factor, frankly, because you always have the benefit of hindsight when you're making that analysis. If someone like me is standing before the court, how am I supposed to prove, essentially, that there was a safer means, or if there wasn't an accident, what have you? So I would submit to the court, Your Honor, that the appellees only raised 7 of the 14 Hoffman factors in their brief, and those were the officers were speeding. Okay, well, on 29th Street, the only evidence with respect to the officer's speed is that they were going 35. It's a 25 mile per hour zone. Surely an officer could go 10 miles per hour over the posted speed limit if they were trying to apprehend a fleeing suspect. The officers were not traveling in the correct lane of travel. Well, the only time that wasn't the
Attorney
case.
I'm going to have to ask you to wrap up.
Okay, very good. I've submitted my briefs. I tried to be as detail-oriented as I can, Your Honor. Thank you for listening here to me today. Happy Easter to you and your families.
Thank you.
Thank you.
May begin.
Okay, a few minutes in the morning, so good morning, Your Honors. My name is, may it please the court, my name is Edwin. I'm here today on behalf of appellees Malcolm Jones and Yesenia Rodriguez. We urge this court to recognize that genuine issues of material fact remain as to the wanton and reckless nature of the officer's conduct in this case in attempting to chase Javion Davis across a grass field and directly into our clients. The core question presented here is simple. Can reasonable minds, viewing all of the facts and evidence in the light most favorable to my clients, disagree as to whether the appellants were wanton or reckless in their pursuit? Plain answer, viewing this incident in the light most favorable to my clients, we submit is yes, and therefore we ask this court to affirm the decision of the trial court. I'll rely on the briefing for the specific definitions of reckless and wanton. It gets a little bit dicey. I would also refer this court to Judge Hensel's dissent in the Anderson versus Westlake case. It has a very good breakdown of exactly what the recklessness standard entails in these kinds of pursuit cases. Now, in the briefing, appellants make a big deal about Bargabre and the Ohio Supreme Court recognizing that this is a high standard. We agree, this is a difficult standard to prove, but it's not our burden to prove recklessness or wantonness at this stage. The question is, again, whether there's a genuine issue of material fact. To that end, the 9th District has recognized that in most cases, recklessness is a decision that should be made by the jury, and especially here because this is a particularly factually specific analysis that needs to be conducted. The briefing discusses the Hoffman factors, counsel discussed the Hoffman factors. The Hoffman factors are the checklist. This is not yes this, no this, yes this, no this. They are examples as part of a totality of the circumstances analysis. We need to take everything that happened here into account. Indeed, in the context presented here, things are particularly factually based. So let's talk about these factors a little bit. This has been covered pretty extensively in the briefing, but as we know, first, the officers were speeding. There's no two ways about it. They're doing 140% of the speed limit down 29th Street. When they reach this grassy field, there's no speed limit for a grassy field.
Counsel, tell me why, what evidence there is to substantiate what you just concluded
That the officers were speeding, Your Honor?
at the rate that you just.
140% of the speed limit is about 30 to 35 miles per hour, which I believe is bolstered by the officer's testimony. So relying only on their testimony, they're already significantly exceeding the speed limit down a residential side street that has houses approaching apartment complexes. And we'll get to a couple more of these facts as we go on, but it's also 5:20 in the afternoon on a Saturday. It's the middle of the afternoon. This is when people are going to be out and about, walking to their neighbors' houses, walking to stores, going to dinner. So the officers are speeding, and they come up on a grass field, which there is no speed limit. I submit that the speed limit is whatever is safe. I would submit that the officer's speed through this field was not safe. And in fact, testimony indicates The officer, I believe Officer Cologne urged Officer Soto to go faster, and Officer Soto refused because he was worried about destroying the SUV they were in. He was driving this car so fast, they were worried that if he went any faster, he would destroy a police SUV.
It was so fast, we know they're going, the only evidence we have, they're going 30, 35 miles an hour, right?
The only direct evidence from them as to a number, correct, Your Honor. Now, I'll talk about these affidavits a little bit that counsel referred to as bald and self-serving. I'll note that the affidavits are by 2 eyewitnesses testifying to what they observed. Now, we can talk about whether they are credible, whether they are to be believed, but those are not proper considerations on a motion for summary judgment. Those are credibility determinations, and I submit that any question about the validity of their testimony goes only to weight and credibility and cannot be considered at this stage in the proceeding. And again, they also testified they were going very fast. A layperson can say, hey, they're going very fast, especially in the circumstances. They were saying they were very close. Now, of course, they'll be subject to cross-examination at trial, and counsel can discuss what exactly that means. But again, these things go to weight and credibility, not admissibility, and not whether or not they can be considered for the purpose of this motion. But now I want to talk about some very particular and important elements here. One of the Hoffman factors, one that I think is critical here, is the seriousness of the nature of the offense that they were trying to catch this guy for. They were trying to catch Davis because they knew he didn't have a driver's license.
No, that's not what the evidence showed. It seems to me they had other concerns about shootings and other things. It wasn't just merely, hey, we run his plate, didn't have a license, let's track him down for that reason. They had other serious concerns that they were looking to stop him to.
I understand, Your Honor, and I agree with that general analysis. There was a great deal of intelligence about this particular individual, and they specifically recognized him. However, so let's talk about, say, Anderson versus Westlake, which featured heavily in the briefs. In Anderson, we were talking about whether the chase was justified based on the offense he was being pursued for. The suspect was fleeing from the actual commission of a felony in a stolen vehicle. No stolen vehicle here. Our guy's not running from the scene of a murder. He's not running from the scene of a shooting. Those concerns are remote in time. So I agree that there are concerns. I agree that a traffic stop was justified. However, whether or not this pursuit through a residential neighborhood and through a field where they knew that residents often would walk is not justified. And to that point, one of these other factors is whether or not there was a safer alternative. I agree that chases are never safe. I agree that chases are sometimes necessary, but here, they knew who Javion Davis was. They knew what car he was driving. They knew what area he was in. They knew about the gang strongholds in the area. They knew about his buddy's house. I submit that there is no compelling reason for them to chase this guy at high speeds through a field when they know exactly who he is, where he hangs out, and how they can get him at a later date. We're not asking for a bright line rule.
How large is this field? Counsel described it as, I'm viewing a commercial lot, not 100 yards, I'm viewing a fairly small field of that.
I don't have the exact dimensions. I believe the briefing suggests it's about 500 or 600 feet across, so 200 yards, give or take. It's not like driving across my front yard. It's a fairly wide open field that creates a gap between the two ends of East 29th. And again, now counsel talks about having the benefit of hindsight when we're talking about safety. I think appellants are trying to access the benefit of hindsight when they're talking about whether or not there are pedestrians in this field. There was no way for the officers to know that before they get into the field. They say this is happening.
Saturday, 5 o'clock, what was prohibiting them from viewing the field by looking to and fro and see if there's people there or not?
I submit that if your attention is on a fleeing suspect in a vehicle running across that field, that's where your attention is. You don't know if there are people walking across it 100% for certainty. And that gets into one of these other factors that Lorain policy says you don't follow people off-road where pedestrians are and where the terrain is unpassable. Well, apparently the terrain in hindsight is passable here, and there was some testimony that they crossed it before, I admit that. But they don't know if there are people currently in that field at that time or not. Certainly not for certain.
Counsel, do you agree with opposing counsel that a violation of departmental policy would not in and of itself be determinative?
I do agree. I do not believe that a violation of policy alone rises to the level of recklessness. However, violation of policy, the seriousness and nature of the crime being pursued, whether or not there was a safer opportunity, which there was here, the speeds that they're conducting, and whether or not the officers disregarded a serious risk of harm, all of these things taken together, again, the totality of the circumstances weigh.
Does the risk of harm have to be to the individuals injured. In other words, in this case, it seemed to me we're arguing there's a risk of harm to people walking in the field. Well, someone walking in the field wasn't hurt. It was unfortunately these people were driving on the road, which is a different risk than people walking in the field.
I understand that, Your Honor. My reading of the case law on this is we're determining whether or not the officers were acting recklessly. So whether or not they disregarded a serious risk of harm, not necessarily a serious risk of harm to a particular individual, and that's why it's so critical that this goes to a jury. There are a lot of questions of fact here. There are a lot of factors here to be weighed out, and ultimately a jury in Lorain, made up of individuals who live in Lorain, who are served by these officers, need to make the determination as to whether this meets that threshold, whether or not they acted reckless in their pursuit of a suspect that they could have easily grabbed at a later date across this field where people, families live nearby. And again,
I have a question just out of curiosity.
yes, Your Honor.
One of the officers knew he was driving under suspension. Did anybody actually check leads to see if he was under suspension? Because that's something you can clear up or not clear up, and sometimes it's an unclassified misdemeanor, sometimes it's a first-degree misdemeanor. Did anybody ever, did they just know that he was under suspension of their own past knowledge, or did somebody look that up? That's
My understanding of the facts, Your Honor. I don't know that there was any, in the moment checking on the laptop or calling it into dispatch or what have you. Yeah, so, again, we need to look at the totality of circumstances, everything that happened here. And the question is not, do we determine right here and now, 100% for certain, does this prove that these officers were reckless or wanton as a matter of law? I submit that it probably does, but that's not the burden. The burden is, could reasonable minds, could members of the jury look at all of these facts and disagree on that point? Is there a genuine issue of material fact? That is the only burden that needs to be met here. We submit that based on all of the evidence in this case, especially on those affidavits that, again, he calls involved in self-serving, I call them eyewitness testimony, which is admissible under the rules of evidence, under the Rule 56, I believe it's 56E evidence, but it's getting away from me there. Under all of these factors, under the totality of the circumstances, knowing where this chase happened, know what they were chasing for, and one last point I want to make, I believe in the motion for summary judgment, they actually did discuss what J.D. Davis was ultimately indicted for. I don't believe he was indicted for those shootings. I believe he was indicted for vehicular assault and possession of a firearm under disability. Again, these are serious crimes, and these are crimes that you could justify a stop for. Now, provided I have enough time to run through this last point, there is one significant factor here that I think came up in the briefing was there's no evidence that this guy's going to stop if the officers stop. I want to address that. I submit if the officers follow Lorain Police Department policy and stop before they enter that grassy field, a reasonable mind can conclude that J. John Davis sees, oh, they didn't follow me across here, I'm free and clear. Counsel noted it was a football field after he leaves this field that he crashes. Maybe he would have slowed down. Reasonable minds could conclude that if they had stopped at this natural barrier and not pursued him across the field hot on his heels, as our clients say, that he would have stopped. It would have been a safer alternative. This entire situation would have been avoided, and clearly, due to the diligent police work of these officers, they would have caught him at a later date. So, again, taking all of the factors in, all of the facts and evidence before us, in the light most favorable to my clients, as required by the standard, we believe that genuine issues of material fact do remain to be determined, and therefore summary judgment cannot be granted at this time. The trial court made the right call, and we urge this court to affirm.
You still have about 3 minutes, so I'll ask you, do you have anything to add regarding your expert?
Yeah, regarding my expert, if they want to present a Daubert challenge down the line and challenge the credibility of his determinations and so on and so forth, that's an evidentiary rule we can discuss in the future. I disagree with the characterization that this is just a bald and self-serving affidavit. Our expert doesn't just say the police officer was reckless, therefore reverse. Especially in our expert's report, he goes into details explaining precisely how those opinions are found, and my recollection is that that report is incorporated by reference into his affidavit. Therefore, it's not just an expert standing up and parroting, hey, they were reckless. He's saying they were reckless for these reasons. I would encourage this court to review the full record with regard to that matter and making that determination. But even if the expert's affidavit doesn't qualify, I do believe there is more than sufficient evidence here to create the genuine issues of material fact, and thus require us to go further in proceedings. Anything else from the panel, Your Honors?
Hearing none, thank you both very much for your presentation. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it's released, and it will also be posted on the Ohio Supreme Court website. Thank you again.
Thank you guys. Have a good Easter weekend.